Submitting Form I-130 is the first step in helping an eligible relative apply to immigrate to the United States and get green card. The filing or approval of this petition does not give a relative any immigration status or benefit. Generally, once USCIS approves the petition, your relative may apply to become a lawful permanent resident. If your relative is already in the United States and a visa is available, they may be eligible to get their green card by filing Form I-485, application to register permanent residence or adjust status. In this video we will give you an answer for all your questions related to I-130 applications.
Please don't forget to subscribe if you're new to the channel.
Now, let's get into the video. Number 1. What is the difference between Form I-130 and Form I-485? Form I-130 is the first step to helping a relative apply for a green card if you are a U.S. citizen or permanent resident and you want to prove that you are related to someone who is eligible for permanent residency. If your relative is already in the United States, they may be able to use Form I-485, application for adjustment of status, to apply for permanent residency at the same time. In some cases, you may be able to file these forms together. Number 2. How do I file Form I-130? You can file Form I-130 either online or via mail. To file online, you need to create an online account with USCIS. This will also make it easier to receive case alerts, check your status, upload supporting evidence and see all case correspondence. You can submit Form I-130 online even if your relative is already in the United States and they plan to submit their Form I-485 by mail. You can also file Form I-130 by mail. If you live in the United States, you will need to confirm to which address to send your petition. Depending on which state you live in and whether or not your relative is filing Form I-485 as well, USCIS will require you to send to either the Dallas, Chicago or Phoenix lockbox. From here, it will be processed at any of USCIS 5 service centers. If you live outside the United States, you may file at the USCIS Dallas lockbox or online. If there are special circumstances, you can request to file at the closest U.S. embassy. Make sure you fill out all sections of the form and sign it, otherwise USCIS may reject it. Number 3. What are the fees for the I-130? An I-130 petition currently costs $535, paid using a check or credit card, using Form G-1450. Number 4. Can I expedite processing for Form I-130? Premium processing isn't available for I-130 petitions, but you can send a special request to USCIS if you want to expedite processing for Form I-130. USCIS will usually only consider the request if there are urgent humanitarian or U.S. government interests. Number 5. Who can file Form I-130? If you are a U.S. citizen, you can file Form I-130 for each of your eligible relatives. This includes your spouse, your children, your siblings, and your parents. If you are a permanent resident, you can petition for your spouse and any children under the age of 21. You can also petition for your stepchild if the marriage that created the relationship took place when the child was younger than 18. Number 6. What documents will I need to file Form I-130? When filing Form I-130, you will need to show evidence of your relationship to the relative you are petitioning for. Some of the documents you may use to prove this include evidence of U.S. citizenship or permanent residence, such as a birth certificate, naturalization or citizenship certificate, passport, or green card. Evidence of family relationship, for example through a marriage certificate or birth certificate. If you are petitioning for your spouse, you will need to provide additional evidence of your relationship and prove you have a bona fide marriage. Some ways you can do this include documentation that shows you own or rent property together, joint bank account statements, and affidavits from people who can confirm your relationship is authentic. Proof of legal name change, if applicable. Number 7. My Form I-130 has been approved. What happens next? Once the I-130 has been approved, your relative can apply for their green card. If they are an immediate relative, such as a parent, spouse, or unmarried child under the age of 21, they may be able to apply straight away. Otherwise, they may have to wait. If they can apply immediately and they are in the United States, they may be able to adjust their status using Form I-485. Number 8. Will I need to go to a biometrics appointment for Form I-130? USCIS may request biometrics information from any applicant, sponsor, or petitioner. After you file your I-130, you will receive Form I-797C from USCIS, which will let you know if your petition has been approved, rejected, or if you need to provide more information. If your I-130 has been approved, this form will also include an appointment notice with a date, time, and location for an appointment to provide biometrics information at your closest application support center. Number 9. What happens if my Form I-130 is denied? There are many reasons why an application may be denied. If USIS denies your I-130 petition, you will receive Form I-797, Notice of Action, in the mail. If you believe your I-130 was unfairly denied, you may be able to appeal to a separate body, the Administrative Appeals Office, AAO, within 30 days from when the notice was sent, not from when the notice was received. Number 10. How can I check my I-130 case status? You can track the processing of your case online using your 13-digit case receipt number, which can be found on any notification letter sent by USIS. Number 11. Will I need an interview for my I-130? For most people petitioning with I-130, SCIS will invite the sponsor and the relative seeking a green card to attend an interview. During the interview, USCIS will confirm the information you have provided. Sometimes, USCIS might be able to approve your I-130 without the need for an interview. If you are a U.S. citizen and you are filing for your parents, or unmarried children under the age of 21 who are in the United States and have filed Form I-485, then you might not need an interview. You also may not need an interview if you are a permanent resident and you are petitioning for any of your children who are younger than 14 years old. Number 12. What if I am missing some of the documents for my I-130? If you do not have one of the primary documents required, such as a birth certificate, then you will need to submit a letter from the relevant authorities to confirm that this document does not exist. If you submit your petition and are missing any of the documents in your application in your I-130, then USCIS might send you a request for evidence, or RFE. However, there is also a chance that officials may deny an I-130 petition if some supporting documents are missing. Number 13. Will my relative be able to work after Form I-130 is filed? The I-130 is a petition to help a relative apply for a green card, and does not give the right to work. The good news is that it's the first step towards gaining permanent residency and the right to work in the United States, and that further down the process, your relative may be able to submit Form I-765 and apply for an Employment Authorization Document, EAD. Number 14. Can I file I-130 and I-485 together? If you file Form I-130 and your relative is in the United States already, you may be able to file Form I-485 together. This process is called concurrent filing. If your relative isn't an immediate relative, such as your spouse, your child or your parent, you may also need to confirm that there is a visa available for them before filing concurrently. For Form I-130 and Form I-485 to be considered together, you'll need to file them at the same time, by mailing them with the required filing fees and supporting documents to the same location. They will also be considered as filed concurrently if you have filed Form I-130 either online or via mail, and it is still pending when your relative files Form I-485 to adjust their status. Since both of these forms are processed by USIS, they are eligible for concurrent filing. Generally, if your relative is not already in the United States, you will not be able to file to adjust status at the same time, since immigrant visas are dealt with by the Department of State. Number 15. Can I use Form I-130 for my spouse or fiance? If you are a U.S. citizen petitioning for a green card for your non-U.S. citizen spouse, then Form I-130 is the first step to applying for a K-3 visa, non-immigrant visa for a spouse. If you are petitioning for your fiancé, you will need to file Form I-129F, Petition for Alien Fiancé, for them to be admitted to the United States as a K-1 non-immigrant fiancé. Number 16. Will my relative be able to travel on an I-130? While the sponsor is waiting for the I-130 petition to be approved, the relative may be able to travel to the United States on a tourist visa, such as a visa waiver or a B1/B2 visitor visa. However, it's important they make it clear to immigration when they enter that they will leave before this visa expires. If they cannot prove this, they may be denied entry. Number 17. Will Form I-130 still be approved if either myself or my relative has a criminal record? When you file a I-130 for your relative, USIS may request an interview or biometric information, such as fingerprints or photograph, from both you and the applicant. This is so they can run background and security checks. If the sponsor has a criminal record, there's a good chance they will still be able to sponsor a relative coming to the United States. If the relative has a criminal record, they may also still be able to apply for a green card. It's important to be honest about your criminal history, and to let us know of any interactions with law enforcement, except for minor traffic violations. Having a police record can make things more complicated, but does not necessarily lead to a green card denial. Number 18. Where should I send my I-130 form? Where you must send your I-130 petition depends on where you live and whether you're filing just an I-130 officially called a standalone I-130, or filing an I-130 with an I-485 green card application, or application to register permanent residence or adjust status, at the same time, officially called a concurrent filing.
I hope you guys found this video extremely helpful. If you know anybody that could benefit from this information, definitely make sure to share this video with them. We are all about empowering you with knowledge, so the more people that can benefit from this video, the more people we want watching this video. If you like this video, please make sure to hit that thumbs icon. Thanks for watching, and don't forget to subscribe and hit on the notification bell for more immigration updates. Bye!